Yes, Mr. Nicholson.
My lord, my lady, Manitou's appeal. To be clear, Manitou's appeal is only relevant insofar as your lordships dismiss JCB's appeal. If the information my clients are concerned about is not in fact confidential, then my clients can have no basis for seeking its exclusion from the judgment. Now, the essence of my appeal is simple. Having decided that heads 1, 2 and 4 were confidential, and it being common ground that head 3 was also confidential, the judge went on to decide that the essence of Manitou's technique, the so-called Criterion X, should be openly published in the public version of the judgment in the interests of open justice, because it would not be possible to make much sense of the court's reasoning on the doctrines of equivalence if the reader was not made aware of what Criterion X is. That's the judgment, paragraph 37. Yes. And the main policy issue where we say the judge erred is that in applying his reasoning, it is almost inevitable that in a case based on the doctrine of equivalence, it will be necessary for the court to publish to the world the successful defendant's confidential technique that underpins its commercial products, which has been found, as in this case, not to have infringed the claimant's patent. Now, to explain why we object, I take it in 4 stages. Firstly, explain the essence of Criterion X. Second, to briefly remind this court of how the doctrine of equivalence is developed. Thirdly, to look at the way the judge applied the Liliaikos authority to the situation. Fourth, where the judge went wrong in his application of Liliaikos. And then fifth, I am going to spend time on the Trade Secrets Directive and show how that assists this court in understanding the relevant policy issues in a consistent manner.
Just a very small point before you go any further. Encapsulating the issue as you described it, you concluded by observing that in the present case, your clients so far have been found not to infringe by the configuration C, but presumably you accept that the answer must be the same even if the finding were infringement. I can't make any difference whether you don't infringe, can it?
There is a distinction to be made. There are two aspects about being an innocent defendant. Firstly, a defendant is not a volunteer to litigation. So it has expectations that it has not conceded knowingly in choosing to come before the court. Secondly, it does make a difference to some extent, or potentially some extent, whether or not the system was found to infringe. Because where the system was found to infringe, the normal relief from this court will be to grant an injunction prohibiting the use of that system. And secondly, so its value in the hands of the defendants or even any third party becomes minimal. And secondly, it will have been found to be materially identical, if I use that non-patent term at the moment, but materially identical to that which has been published in the patentee's patent. So I understand your lordship's contention that in principle the protection of confidential information has got nothing to do with whether I've won or whether I've lost. But the situation that arises when somebody is innocent is somewhat different to the situation that arises when they've been found to infringe.
All right, that then leads on to the follow-up question, is what's the position pending appeal? Because, of course, the finding of non-infringement may be reversed on appeal, and it could be reversed again in the Supreme Court. Likewise, even if there'd been a finding of infringement first time around, that could be reversed on appeal.
Absolutely, my lord, and it's like any other relief in a case.
So how do we, sitting here, know for certain that you're not infringers?
the usual procedure in this court is to proceed on the basis that the judgment that's rendered at the moment makes me innocent.
But there's a pending appeal against
But there is a pending appeal, my lord. But the same as whenever anything is pending, the issue as to whether or not the protection afforded to confidentiality may need to be amended.
So the logic of that is we have to wait until the substantive rights of the parties have been finally determined, and all rights of appeal exhausted, before we can address this issue.
To address this issue finally, yes, my lord.
And you say in the meantime we play safe.
In the meantime, one cannot publish the information in the meantime, because if it's released, once it's released,
yes,
it can't be closed. And the natural way to deal with this would be for the final order, as in this case, to decide that I'm innocent, to deal with my confidentiality as one of the consequential matters that goes with that. Then that order, including any decisions as to confidentiality, to be appealed to this court and adjusted accordingly. And insofar as there is to be an appeal to the Supreme Court, ring held, exactly what will happen.
On that basis, we're out of sync. Because, I mean, I can understand the logic of what you just suggested, but here we're dealing with your appeal on confidentiality in advance of the substantive appeal.
We are, my lord, and my client's position had always been that this was not a separate self-contained matter, that it conveniently and appropriately should be heard with the substantive appeal in January. It's my learned friends who are in the interests of justice but might want to grab hold of my confidential information to get it as early as possible, who've said this is a self-contained matter and they want it heard as soon as possible. So here we are. But your lordship is absolutely right. In the normal course, this would be dealt with in the same way as any other consequential part of the court's order from the final order hearing. It would all come up together and it would all go up to the next stage together. And it may well be that in many cases, the innocence or not of the defendant doesn't make a material difference. And whether the finding flips over between the different courts may or may not have an effect. But I do say an innocent defendant is entitled to engage in the litigation process in this country. And if it shows that the claimant's case against it is without merit, it should leave unscathed. It shouldn't have to pay for the price of successfully defending a unsuccessful allegation of patent infringement, the price of having its confidential information published to the world. My lord and my lady, criterion X. As we've explained in paragraph 46 of our main skeleton, it was common ground at trial that Manitou's configuration C machine achieved substantially the same technical result as JCB's patented system. What was disputed was whether or not Manitou achieved the technical result using the same inventive concept as taught by the patent. To adopt patent language, criterion X is Manitou's inventive concept. In more traditional confidentiality language, criterion X is perhaps Manitou's secret sauce. In either case, how it solves the problem, but without infringing JCB's patent. Now, as we discussed earlier, taking Manitou's secret sauce or inventive concept and implementing a commercial machine absolutely requires an awful lot of engineering effort. Precisely the same, however, applies to implementing JCB's inventive concept. One picks up somebody's patent, right, let's assume after expiry, and says this is now gifted to the world and I want to implement it. The same huge engineering effort goes into producing a commercial product. We also remind the court that Manitou and JCB are major competitors, that we didn't choose to be sued by JCB, and it brought the claim against the configuration C machines, which is thus far found to be without merit. And as I've said, an essential part of Manitou meeting the expectations of the court in the jurisdiction is it had no choice but to tell JCB and the court what its secret source was, albeit under strict terms of confidence during the litigation process. The confidentiality regime being in place because the Patents Court well understands that competitors ought not to be able to sue each other and then require them to freely disclose important confidential techniques. But disclosure is nevertheless necessary for the court to be able to determine the issues before it. Now, that's criteria X. The doctrine of equivalence. At paragraph 36 of the judgment, which is in core tab 11, paragraph 36 on page 84. The court explains, this is in the judgment obviously on the publication issue, turning to the specifics of this case, as counsel agreed, the potential difficulty in understanding the reasoning on infringement in the annex comes in the passages explaining my conclusions on equivalence. Now, at least my Lord Justice Arnold will well appreciate, but for the benefit of us all, the judge is here referring to a relatively new concept in English patent law, known now as the doctrine of equivalence. Now, prior to the Supreme Court's decision in Actavis and Eli Lilly in 2017, the UK court had firmly held on to the notion that there was only one correct construction or interpretation of the language of the claims of a patent. And of course, it's the claims of the patent which define the scope of the patent's monopoly. Now, we maintained this approach in the UK, notwithstanding that UK patent law is in part derived from the European Patent Convention, which recognises a two-stage process of normal construction followed by including equivalence, which enables the claims to be extended to cover the inventive concept taught by the patent, even though it requires some departure from the actual language of the claims themselves. Now, to give a very simple example, if a claim says Part A is screwed to Part B, under the old law of a single-step purposive construction, we ended up deciding that screwed could perhaps also mean glued. Perhaps unsurprisingly, the time came in Actavis and Eli Lilly where the Supreme Court said, enough of this. Screwed has to mean screwed on a normal purposive construction, and whether the claimed monopoly should fairly extend to glued is a separate question of equivalence. In the particular case before that court, the court was being asked to hold that a claim to a sodium salt included a potassium salt, and the Supreme Court said that we cannot continue to pretend that the word sodium includes potassium. Applying the doctrine of equivalence requires the court to identify the so-called inventive concept of the patent. So in my screwing example, the court may well decide, having read the patent with expert assistance, that the real inventive concept of the patent is Part A is firmly affixed to Part B. Now, against such a determination, equivalence is addressed with three questions. The first question has two parts. Does the alleged infringement achieve substantially the same result as the inventive concept? That's the first limb. The second limb, and does it do so in substantially the same way? If that question is asked in affirmative, one moves on and questions whether the same would be obvious to the skilled person. And if that is answered in the affirmative, there's a final question as to whether or not the patentee should be intended to require strict compliance with the actual language which has been used in the claim. Now, for present purposes, we can forget about the second and third questions, and in fact focus on the second limb of the first question, for that's where the issue arose at the trial in this case. first limb achieves the same result as agreed. The problem comes with the second limb. Does it do so in substantially the same way? In my glue and screw example, the first limb, does gluing achieve substantially the same result of securely affixing parts A and B? It's probably answered easily yes. But then the court has to, again with the assistance of the experts, compare and contrast the principles of gluing with the principles of screwing to decide whether they do achieve the result in substantially the same way. And the outcome may well depend on, for example, the way the forces in the patent between parts A and B are to be subjected. If one is interested in a pulling force between two plates, it may be that screwing and gluing are substantially the same. If, however, the invention needs to oppose a shear force between two plates, gluing and screwing may not operate in substantially the same way. It all depends on the detail. It calls for a careful comparison of the inventive concept of the patent and what I'm calling the inventive concept of the alleged infringement. And contrary to JCB's assertions, this isn't something which occurs in anything like the same way on normal construction, as was well indicated by the substantive judgment in the trial before the court. If we turn to core 9, core tab 9, which is the redacted version, which is already published, and my clients say is all that should be published. If we turn to page 67, starting at the bottom of the page, we've got the section on normal infringement. And there's a little bit of setting out, but the core paragraphs are 40 and 41. Now, as my lords and my lady will see, there is some redaction going on there. But the bit that is in black, which is redacted, is head 3 information, and it's common ground. It doesn't need to be included in the judgment.
Sorry, I'm just... you asked page 67.
67 is where the setting normal infringement starts. Just
Right, I'm done with you. So we're now on to page
and then I've skipped
69.
forwards to the key decision of the court at 40 and 41. The redacted bit isn't disputed. That's never going to be published. And the rest of the paragraph requires no redaction at all. And the reason for this, I suggest, is that on a normal construction, what the court does is decide what the claim means, and then ask the question, does the infringement have the feature for each of the integers of the claim? So, for example, on a normal construction, the claim says screw, decides that screw has its normal and everyday meaning. The question for the court on infringement is there a screw in the alleged infringement? And all the court has to say is yes or no. It doesn't have to say no, the closest thing the infringement has is glue, or even no, it has glue instead. As we've sought to explain, on equivalence, the question rapidly becomes one of comparing and contrasting the requirement of the patent with what is present but different in the alleged infringement. In other words, is glue substantially the same as a screw? And that comparison and the ultimate answer is at the heart of the court's decision on whether the product infringes under the doctrine of equivalence or not. And that's precisely the situation that was before His Honour Judge Hacon, and why he says in paragraph 36 that the potential difficulty arises in understanding the reasoning on infringement in the annex comes in a paragraph explaining my conclusion on equivalence. And as the judge then went on, it's worth turning up, so paragraph 11, I'm sorry to go back to it, page 84. The judge went on to explain, starting in the middle of the third line, the principal issue was whether the result achieved by Manitou's configuration C system is substantially the same as that achieved by the inventive concept of Claim 1 of the patent in suit, and achieved in substantially the same way. I found it was not achieved in substantially the same way, explaining my reasoning by comparing how the invention in suit works with how Manitou's system works, which includes a reference to Manitou's use of criterion X. Then at 37, it seems to me that it would not be possible to make much sense of that comparison if the reader is not aware of what criterion X is. I must therefore assess the potential damage to Manitou. Now, against that background, the judge turned to applying Liliaikos to determine whether or not he should publish his reasoning on criterion X, notwithstanding that he had already held that criterion X was confidential to Manitou. Now, as the court will have seen picking up in our main skeleton at paragraph 56, Liliaikos is an open list of considerations which this court, the Court of Appeal, found helpful in determining a particular case in front of it. Now, we have no real problem. One could argue around the edges, but we have no real problem with the judge's various summaries and sub-summaries of bringing points together to say there's two balances and two opposing balances. Because our real complaint is he doesn't go on to apply them anyway. Where we take issue is with his actual purported application of Liliaikos, which is wholly set out in the judgment at paragraph 37. At this point, all of the multifaceted questions of balance have disappeared. The judge simply notes that it would not be possible to make much sense of his determination of the necessary comparison for applying the doctrine of equivalence without revealing criterion X. And going back to the judgment...
Well, just pausing there. Do you dispute the judge's assessment that it would not be possible to make much sense of the relevant part of the judgment if the reader is not made aware of what criterion X? And if so, upon what basis? Because is that not an evaluation by the judge, who is pretty well placed to make it?
I don't object to it, and for the reason that your lordship gives. At the very least, however one looks at it, there can be no doubt that the judgment is more accessible and more clearly explains what the judge was saying when you can see all of it. And the judge is by far the best person to look at his own judgment and his own reasoning and say, I think this is an important part of my judgment. So I don't challenge it. So just going back...
Well, before you resume, can I therefore ask you the next question? Because he goes on to say he must therefore assess potential damage to Manitou if criterion X were to be made public. Now, do you criticise that as a question that he asked himself? Do you say that that's a question he shouldn't have asked? Or do you say he gave the wrong answer, or what?
My lord, I say he erred in expressing the test in this simple way. Once I have decided that this is an important part of my judgment, it is going in unless I am convinced that this is going to cause serious harm to Manitou, is ultimately what he applied. And I say that throws Liliaikos out of the window. The balance has gone. He isn't doing what he was required to do. And one can actually see the source of this going all the way back to paragraph 18 of the judgment, where the judge set out the test he was going to apply. I think I'm in the right paragraph.
18 is right.
18 is right. I'm going... set out the test that he was going to apply before he'd even heard argument on the application of Liliaikos. He says, applying the balance of the facts to the present case, I take the view that it means that the greater the need to use the information in issue to me explaining my reasoning in the judgment, the stronger must be the evidence of potential damage to Manitou, were that information to be made public.
So you say that's wrong.
I say that is massively oversimplistic and wrong. And let me explain why. All the multifaceted questions of balance have disappeared. The judge is simply noting these, once I've decided to publish it, then it goes to damage humanity. The essence being that because Criterion X is at the heart of the decision on infringement, Manitou must put up very strong reasons to overturn the presumption of publication needed in the public interest. All the nuance of Liliaikos has been lost. For example, balancing the difficulties it will cause future patent trials in this jurisdiction if a defendant cannot be reasonably sure that its confidential information will be protected, even if he's found innocent. Over Liliaikos express principles 25 in paragraph 25 sub 5 and 25 sub 6. These important considerations simply form no part of the judge's assessment. What the judge has done...
Mr Nicholson, for my part, I'm clearly not familiar with this jurisdiction. At some stage it will help me to go to Liliaikos. I'm sorry if I'm the only person in the room who
No.
ask that, but for me to understand your submission that paragraph 18 is massively oversimplistic and wrong, I'm afraid I need my hand held in and going to where you say Liliaikos shows that.
Then let me do that, my lord.
And for my benefit too.
And my lady. So I'm in the authorities bundle. I'm at tab 2. And I'll confine myself to paragraph 25 for the moment. But there's a couple of other things I will pick up shortly in the wider discussion of the court. So this is Authorities, tab 2, page 11. And here, the Court of Appeal is saying it may be convenient to set out a number of considerations that have guided us. This isn't a closed list of what one does. It just happens to be what guided in this case. 25.1 does say the court should start from the principle that very good reasons are required before departing from the normal rule of publicity. And then there's some various references to that. Sub 2, when considering an application in respect of a particular document, the court should take into account the role that the document has played or will play at the trial, and thus its relevance to the process of scrutiny referred to by Lord Diplock. Should start from the assumption that all documents in the case are necessary and relevant for that purpose, should not cede to general arguments that it would be possible or substantially possible to understand the trial, judge and judge without access to particular documents. Centrality of the document to the trial is a factor to be placed in the balance. 3, in dealing with issues of confidentiality, the court must have in mind any chilling effect of an order upon the interests of third parties. 4, simple assertions of confidentiality that will be done by publication, even supported by both parties, won't prevail. Specific reasons are necessary. And then 5, which was the first one I was directing my lords and my lady to. It's highly desirable, both in the general public interest and for simple convenience, to avoid holding trials in private, or particularly in private. In the present case, the manner in which the documents were handled, together with the confidentiality agreement during trial, enabled the whole trial to be held in public, even though the judge regarded it as justified to retain confidentiality in respect of a significant number of those documents after the trial was over. The court should bear in mind that if too demanding a standard is imposed on CPR 30.122 in respect of documents that have been referred to or inferentially or in short at the trial, it may be necessary in order to protect genuine interests of the parties for more trials or parts of trials to be held in private, or for instance for parts of witness statements or skeletons to be in closed form. And then 6, patent cases, and this is expressly patent cases, are subject to the same general rules as other cases, but they do present some particular problems and are subject to some particular considerations. Referring to SmithKline, patent litigations of peculiar public importance, as the present case itself shows. That means the public must be properly informed, but it means at the same time the issues must be properly explored. in the sense that parties should not feel constrained to hold back from relevant or potentially relevant issues because of their legitimate fears on the effect of publicity. Now, I'm going to skip the bit about Bonsall because the law has moved on, and it'll probably take too long to explain where we are and why that's misleading. In our view, the same considerations can legitimately be in the court's mind when deciding whether to withdraw confidentiality from documents that are regarded as a party as damaging to its interests if used outside of the confines of the litigation on which they were disclosed. So we say those express concerns under little 5 and little 6 don't form any part of the judge's assessment, nor is there much of a balance between public importance and Manitou's confidentiality. Is much more, there is a default position that we are publishing unless Manitou can show serious reasons. And what we respectfully say the judge has done is to treat open justice as virtually sacrosanct, contemplating not publishing only if the potential damage to Manitou is sufficiently high. At paragraph 38, the judge contemplates a scale from negligible to a threat to the continuation of Manitou's business. But yet there's no determination of where the magic threshold should lie, and no balancing exercise taking place at all. What the judge goes on to accept is that because of Professor Plummer's evidence that a competitor would still have a lot of work to do to implement a commercial system, the damage to Manitou is insufficient to overcome the need for open justice. Now, against this background, we can pick up our discussion as to where the judge specifically went wrong in our grounds of appeal, by reference to our grounds of appeal in paragraph 67 of the main judgment. 67 of our main skeleton. As one does when one sits down to draft this after drafting the grounds, I'm starting with ground 2 with your lordships and ladyships. Misunderstanding the importance of transparency. The fundamental problem with the judge's ultimate purported application of Lily Icos is that he failed to appreciate the importance of transparency or open justice in the overall function of the court. Paragraph 58 of our main skeleton, we've quoted from another part of Lily Icos, which acknowledges the importance of the House of Lords speech of Lord Haldane in Scott and Scott, which makes absolutely clear that the court in Lily Icos firmly understood that the court's paramount objective is to do justice, and that the general rule as to publicity is a means towards that end, and it must yield to justice itself. Now, the very simple point we make is one of policy, is where a party, especially an innocent non-volunteer to the litigation, is required to disclose materials which the court has held to be confidential. Justice requires that the property, if we view confidential information as such, is not destroyed by the litigation process. Indeed, Scott and Scott especially recognises litigation as to a secret process as being a special category in which the effect of publicity would be to destroy the subject matter.
So, can I be clear how far you go? Is it your submission that once the court has held that your information is confidential, that is the end of the inquiry?
I do go that far, my lord, and I will also show my lord.
That must be flat contrary to Lily Icos.
I think it is potentially flat contrary to Lily Icos, but it's the position that's reached on the Trade Secrets Directive. And when your lordship says flat contrary to Lily Icos, one has to be a little bit careful. Lily Icos isn't talking about publication in the judgment. It's talking about the raft of papers in the litigation and making those available. It's also not providing a totally closed list. It's merely considerations that apply to that court. And it appears to be dealing with circumstances where there isn't a justice issue which is put above the confidentiality issue. Well, we'll see when we come to the Trade Secrets Directive. This is the approach that the legislature has taken on trade secrets. It's a trade secret, it's not going in the judgment.
Well, we'll come to the directive, because I can understand the arguments that the law has moved on by virtue of the directive, because of course that's well after Lily Icos. But I mean, if we stick with Lily Icos for the moment, that recognises, does it not, that there has to be a balance struck. One of the key considerations of which is the centrality of the document or the information to the process. And therefore, if it's marginal, as it was in that case, then the balance will tip in favour of protection. If, on the other hand, it's central, that doesn't determine the issue, but the balance tips more towards open justice.
Yes.
And whereas your submission, taken to its logical extent, as I think you accept, is that there is no such balance.
That is the reality of the case, and the point that your lordship makes is that this court in Lily Icos wasn't faced with a trade secret at the heart of the judgment. But Lily Icos did recognise that cases where something that was or akin to a trade secret was at the heart of the judgment did exist. And going back, relying on Scott and Scott in the House of Lords, those cases fall into a different category. Justice requires that they are protected, not that we're into a balancing issue of conveniences or relative harms. And so picking up, Scott and Scott identifies secret process as a special category, although we haven't quoted it in our skeleton. Paragraph 18 of Lily Icos, also quoting Scott and Scott, also refers, for example, to wards of court in the family division, where the court is really sitting primarily to guard the interests of the ward, and that must be paramount over publishing in the interests of open justice. Now, we say the judge's first error was therefore to wrongly weight transparency over justice, and indeed the concept of the court's paramount objective in delivering justice simply doesn't feature in the judge's reasoning at all. Had the judge taken account of that paramount principle and recognised that Criterion X was Manitou's secret source, its inventive concept, of substantially equal value to the skilled person as JCB's inventive concept, he would have probably started from the basis that open justice must yield to confidentiality and not the other way around. That brings me on to my ground 3, misunderstanding the relevant damage to Manitou. Having taken the approach that he did, putting a huge burden upon Manitou to show a level of damage to overcome the principle of open justice, the judge then made Manitou's burden all the harder by misdirecting himself as to the relevant factors. He relied exclusively upon Professor Plummer's evidence that the advantage to a competitor would be dwarfed by the huge effort required to produce a commercial product. The judge took no account of a number of important points that we list at the top of page 21 of our skeleton, 1 through 4. He overlooked the shortcut publication advantage that would be given to a competitor, as he had already found. He overlooked his own acceptance that this was not a case where Manitou was secretly using a known technique. Rather, it was a technique which no one suggested was known outside of Manitou at all. Thirdly, and the distinction I make there is, maybe I've got a choice of 10 different techniques I'm using. Those techniques are all known to those in the industry. The fact that I'm using technique E doesn't have very much exciting to say about it. The fact that there is an 11th category and what it is in a different world. The judge, my third point, the judge ignored the clearly correct assertion made and recorded in the judgment that the value of the concept to competitors was threefold. Firstly, it gave them a strong signpost of what development to pursue. Secondly, it gave them reassurance that it was worth pursuing because Manitou had shown that it worked for real commercial products on the market. It wasn't a hypothetical idea that you might expend huge amounts of research on and then find it wasn't good enough. Manitou can get it to work. I can get it to work too. And then thirdly, it was worth pursuing because not only would it allow one to compete with Manitou and with JCB with products that operated in materially the same way, it was a way that you could do it without infringing JCB's patent. And then fourthly, downplaying the value of the information, the judge ignored the level of the generality of Manitou's confidential concept. And in this respect, we have to look at it in the context of the overall PPD that was being revealed as well. It was akin to the conceptual disclosure of JCB's patent. Both require Professor Plummer's huge amount of effort to implement a commercial product. Yet everyone's happy to accept that JCB's patent is clearly valuable, but similar information protected by confidentiality in my client's hands apparently is not. Stepping back, we say that had the judge evaluated the downside to Manitou in this way, he would have realised that he was proposing to publish a secret source and not some arbitrary bit of technical data in the context of a massive engineering project. We then say our ground 4, failure to take account of the doctrine. The judge's approach takes no account of the fact that it was wholly motivated by the special legal questions which arise in the context of the fairly new equivalence case of this type, although he recognised that it was important because it was at the heart of the judgment decision, and he gave permission to appeal because it was on the basis of new law. This should, of course, pause for thought as to whether equivalence cases where the defendant's alternative approach is secret, whether they form what Scott and Scott called a class which stands on a different footing. And we say, obviously, that they do. If the judge had done so, he may well have appreciated that in doctrine of equivalent cases, it is quite likely that it will not be possible to provide detailed specific reasoning where the infringing process is a valuable asset of the defendant protected by confidentiality. And the judge's failure to do so means that confidence cannot be assured to a defendant who has a confidential secret process which is, rightly or wrongly, accused of infringement on an equivalent basis. But another way, the judge's approach is ripe for abuse in that a patentee can deliberately choose to assert equivalence, where he might not otherwise have done so, or even with very little expectation of success, simply in order to obtain information about what the competitor is actually doing in order to compete with them. In this context, we remind the court that it's normal practice in a patents court not to permit any person capable of utilising the technical information in the PPD to have access to that information. Confidentiality clubs routinely include some management personnel capable of giving the legal team and the independent technical expert, that's the independent technical expert, their instructions. But they exclude technically qualified employees of the patentee. This is precisely the form of order that was made in this case to keep the PPD information away from JCB's technical staff. For that matter, I add, and foreign lawyers. The publication in the judgment and all the underlying documents once the judgment has been published drives a coach and horses through the safeguards which are well established to protect defendants accused of patent infringement. And that brings me back to ground 1, the failure to consider the effect on CPR 3122 and CPR 39.2, trials in private. Liliaikos emphasises the need not to over-restrict the use of 3122 to enable the court to conduct its business. It also points out that 39.2, hearings in private, are often avoided or avoided to a significant extent by sensible use of...
I don't understand the relevance of this argument in the present case, because in this case, not only was a pro tem 3122 order made, but in addition, the court did set some of the time in private.
Your Lordship is absolutely right. Prior to the judgment in this case, it would be routine to assure a defendant who was reluctant about having to disclose detailed and valuable information that the court respects confidentiality. But
my point is, it would have made no difference to the issues we're concerned with if the entire trial had been conducted in private. Because what we're concerned with here is the product of the trial in the shape of the judgment. And of course, as you rightly point out, we have to bear in mind the knock-on consequences of the underlying documents. But what's front and centre in this case is the court's judgment, which is the product of the trial, not what actually happened at the trial itself.
There is, my lord, but the consideration of this is that if the court accepts that the trial is in private and the evidence is in what Liliaikos refers to as closed form, the implication from that is that the judgment will maintain the same process. The concern with the existing mechanism that we have, that was used extensively and with significant reliance in this case, is that 3122 orders are made pro tem. Unfortunately, we still use the Latin. They subsist until the final order hearing in the trial, and then they have to be renewed. And when one's acting for a defendant and they are concerned about their confidential information, what is routinely said is 3122 order will be applied. We can proceed with the trial at that basis, with nobody really arguing out the confidentiality or the way in which it's going to be handled in the proceedings. And if it's truly confidential, at the end of the trial, you will receive an ongoing protection. It won't all end up in the opposing party's hands. And the difficulty with the result, which just says this has got to be really critical to you if I'm going to protect it, is that defendants are going to be very concerned whether or not they're going to get the protection until they get to the final order hearing. And what that's going to lead them to do is not accept a pro tem confidentiality order, which is almost never argued out. It's the whole point of making them pro tem. There is going to have to be a significant confidentiality dispute where the court decides whether the information is confidential.
But how can it possibly do that? That's what I don't get. Because we are concerned here with the court's reasoning in its substantive judgment. So how can you know what that reasoning is going to be in advance of the trial? Because what you're postulating, I understand the point is, well, defendants are going to be fearful, and therefore they're going to seek in advance of trial a final determination of the protection available for their trade secrets. But how can you do that when what we're concerned with is the product of the court's reasoning after trial?
So, one ends up with at least two different things. One is that the defendant is told that if they defend this litigation and hand over their trade secrets, there is a risk they will be published. And the defendant, although he's a defendant to the litigation, he does have the option of submitting to judgment, leaving the jurisdiction, getting out. If it was really valuable to them, that is an option. Or they can properly have out in front of the court how critical they say it is. And if the court agrees with them at that early stage, yes, look, we accept this is not just confidential, this is, what did HHJ Hacon call it, critical to the continuation of the business. The court has accepted that that is the status of this confidential information. You can then go on forward with a reasonable confidence that at that level that has already been recognised, even if it does turn out to be central to the court's reasoning, it will be sufficiently protected in the judgment. The difficulty with the approach that has been given is that the general assumption that provided the material is not trivial, it's got a decent level of confidentiality to it, it meets, as my Lord Justice Arnold put it earlier, clearly trade secrets, that they will be protected, even if they form an important part of the judgment. A defendant being told they'll have to wait and see, I respectfully submit, is going to cause significant problems as the court seeks to proceed.
Surely it would be difficult for the court at a very early stage to have a sophisticated evaluation of whether this is at the very core of your business or not. That someone in a defendant's position is very likely to say this is the most important thing and this is existentially
my Lord,
important for our business. But it's only once the judge has had the trial and they've looked at the conflicting patterns of what could be known, what would be known, that really the judge can have a proper view about that.
My Lord, I wholeheartedly agree. And as you say, once you've seen the material, you've understood what the material is, you've heard about the experts, you're in a much, much better. And that's why the scheme that we have at the moment has been routinely used for years. Of a pro tem 3122.
Sensible way of proceeding.
It's a sensible way of proceeding. And it's, as are product and process descriptions, where you provide a really isolated setting out of your material. It's great when defendants go down that route. It makes both the parties' jobs easier, it makes the court's job easier, it allows for good administration of justice. But these things are done on the expectation that in the normal case, when you get to the end of trial, the renewal of the 3122 order on information which is truly confidential is readily brought into effect. And that's what Lily Icos recognised. We don't want to get too restrictive about handling it. And indeed, what one sees from the cases and the authorities being relied on by both sides is it's very rare for the parties to end up disputing the 3122 at the end. It's only in the special circumstances.
Yes, the normal problem is that the parties agree and the court is dubious.
Maybe so, but your lordship's right. Probably more gets sealed up than perhaps should be in cases because parties act reasonably. We do have an unusual situation in this case where my learned friend's client, for whatever reason, is very desirous to get its hands freely on this information. And it really is calling into question exactly how easily a 3122 order should be granted.
Your submission is that the answer to this is for Lily Icos to be applied properly. You say the judge, with respect to him, didn't. And if Lily Icos is applied properly, you say all will be well because a properly confidential piece of information will remain confidential because justice the importance of respecting the outcome.
Absolutely right. When your lordship says Lily Icos, I mean Lily Icos with the Scott and Scott Rider, which is in Lily Icos itself. That you recognise trade secrets or confidential information in technical patent trials.
So we've gone round a loop contemplating a disastrous situation that you've described, but in fact the answer is you say to do it properly.
Yes, absolutely. And if the judge was going to change to if it's important to my judgment, it's going in unless there's a serious harm, which I say is not Lily Icos, it's much simpler, then he needed at least to take into account what damage he was potentially doing to the ongoing application, which relies on Lily Icos with Scott and Scott providing an appropriate level of protection. And that should have been in its balance, and it's nowhere to be found. I think I've picked up most of those points through. The only other one is also within ground one. The judge took no account of the willingness of parties insofar as they have a choice to resolve their patent disputes in this jurisdiction. If the price of litigating in the UK is the revelation of one's confidential technical information, one can expect a great reluctance to litigate here. Insofar as you have a choice, you go elsewhere. Insofar as the other side are trying to drag you in, one starts looking at more challenges to the jurisdiction, other forum shopping issues, things to try not to be here if I know that being here is going to reveal my information. That brings me then to public policy, my fifth ground. As I've dealt with in my skeleton, public policy really rides throughout all of my foregrounds. I do have it as a separate limb, but I don't think I can assist the court by running public policy in isolation. It's more assistance to run it in the context of the rest. That brings me to trade secrets, which really does shine a bright light on the difference between the approach Manitou advocates for and that adopted by the trial judge. We put it on the basis of what learning can be extracted from the Trade Secrets Directive and, of course, the regulation. And we can pick this up in our supplemental skeleton at paragraph, it says, which is never, yes, paragraph 17. Now, here we've addressed Article 9 of the directive, which was implemented with the usual reorganisation, redrafting, as Regulation 10. The main objective of the Trade Secrets Directive is to provide a floor and ceiling in cases where a party is seeking to enforce trade secrets. Now, an explanation for the need for confidentiality in trade secret enforcement proceedings is explained in recitals 24 and 25 of the directive, which we've quoted on pages 6 and 7 of our skeleton. 24 deals with the fear that discourages litigants from asserting trade secrets. They're concerned that if they assert them, they will become published in legal proceedings. And obviously this is speaking across the whole of Europe. Generally, the UK has been considered to be a better forum in this respect, noting that protection should be provided and remain in force after the proceedings finish. So once these, the last three lines, such protection should remain in force after the legal proceedings have ended and for so long as the information constituting the trade secret is not in the public domain. The point I was making to my Lord Justice Arnold before the short adjournment. 25 explains some of the mechanisms that should be available to protect trade secrets in litigation. They include publishing a full judgment only to a confidentiality clause, which includes at least one representative of the parties and their lawyers, and then publishing a non-confidential version for the rest of the world. Importantly, the recital expressly recognises that this is so even though assessing the nature of the information is one of the main purposes of trade secrets litigation, the legal proceedings, implicitly recognising, therefore, that assessment of the trade secret is at the heart of the court's judgment. Now, these are reflected in Directive 9 and Regulation 10 as it's been enacted. And it may help, my lords and my lady, to have the regulation open from Authorities Bundle tab 12. On page 319. And also page 7 of my supplemental skeleton, which tries to provide a little bit of a guide through it. Section 10.1 imposes an obligation on participants to the litigation not to use or disclose the trade secrets or alleged trade secrets that they receive in the course of the litigation. Now, 10.2 is quite important because the obligation referred to in paragraph 1 remains in force after the proceedings have ended, subject to paragraph 3. The point is, it's an automatic continuation on, reflecting what was said about the need to continue after the proceedings in the recital. 10.3 then provides the only exceptions to 10.2, and there are two of them. Either the court finally decides that the material is not a trade secret, or the information ceases to be a trade secret. Just pausing there, thus far there is no power or discretion being given to the court to set aside the confidence obligation in the interest of open justice or on a balance of harm or otherwise howsoever. You get the protection, it automatically continues unless the court decides it isn't a trade secret or it ceases to be a trade secret. The 10.4 then allows the court, either on an application or its own initiative, to order the measures set out in subparagraph 5 as may be necessary to preserve the confidentiality of a trade secret in the course of proceedings. Now, there's a menu in 10.5 of the minimum tools the court must have at its disposal, and it obviously has a discretion as to which of those tools to use. There's no reason, I would submit, for it being viewed as a closed list, but the object to preserve confidentiality is not discretionary. Indeed, the court is entitled to act either if neither party has made an application to ensure that that objective is met. Then 10.5 lists the tools. They include things with which we're familiar. A is confidentiality clubs. B is hearings in private. And then importantly, C, for present purposes, make available to a person who is not one of the persons in the confidentiality club a non-confidential version of any judicial decision in which the passages containing the trade secrets have been removed or redacted. This makes absolutely clear that one of the tools which the court must have available to itself to preserve confidentiality is a redacted judgment. 10.6 provides a safeguard.
Just pausing there, so that the 5, the court may, A and B, may C, make available to a person who is not privy a non-confidential version. It doesn't say the court may make a confidential version of the judgment public.
Agreed.
So it says, of course, the court can make an anodyne version of the judgment public, but it's, that was the first time I've looked at this, so I may be wrong, but
that's exactly the point that I'm making.
It doesn't permit the court to do what the judge is doing here.
Exactly, my lord. And what one sees is it recognises that a non-confidential version for the rest of the world to see is one of the routes the court can take, to it whilst ensuring that the obligation of maintaining the trade secret provided by 1.2 with the exceptions in sub 3 is maintained.
But if it is a trade secret, then certainly this regulation doesn't give the court permission to make it public.
That's
its own motion.
That is my submission. It's automatic, and that's what happens. Yeah. That's the minimum level of protection the court is provided to give. 10.7 includes a discretion on the use of the tools in 10.5, where account is taken of an effective remedy, a fair trial, legitimate interest of the party, potential harm to the party. And those discretions are really about not allowing the use of the tools to go further than necessary. An important one being effective remedy. The remedy can hardly be effective if the trade secret is revealed. And then 10.8 provides some definitions, but the one that's most important for present purposes is the definition of legal proceedings, which are those relating to the unlawful acquisition, use or disclosure of a trade secret. Now, standing back, what we say is that the regulation is clearly intended to ensure that when trade secrets are enforced in the UK, they will be protected in the litigation process. We respectfully say there is no discretion to throw the baby out with the bathwater and reveal the trade secret. Now, really importantly for the present case, it must be the case that the European legislators and the UK legislators had firmly in mind the centrality of the trade secret to any enforcement case, because they say as much in the recital to the directive. Yet they, and consequently the judgment, yet they were satisfied that transparency or open justice was sufficiently safeguarded by ensuring that the full judgment was available to the confidentiality club, including the client representative, such that the rest of the world having a non-confidential public version redacted to remove the material at the heart of the dispute was not objectionable. That's what happens in trade secrets if they are advanced in a trade secrets case. And going back to the initial discussion I had with my Lord Justice Arnold this morning, one of the reasons potentially why trade secrets aren't raised in this case is that the whole of the regulation, or certainly the important article, which ends up as Regulation 10, the protection in the course of legal proceedings, is restricted in subsection 8 to legal proceedings relating to the unlawful acquisition, use or disclosure of trade secrets. And I have no doubt my learned friend would say the section doesn't apply even if what you've got
it's parallel, because as we all know, Article 9 was already was brought in to address the problems which existed in some legal systems in Europe which didn't have adequate means for protecting trade secrets and that were being litigated. And what's happened, as I'm sure many people will be aware, is that the protections that have been introduced through the Trade Secrets Directive have in some countries been cloned into patent proceedings, thereby stopping up the hole that they had in their domestic procedures for dealing with patent cases. And it's quite understandable why they've done that, because the considerations are exactly the same. It's just that as this case illustrates, in the one case you're talking about a claim for enforcement of trade secrets as against misuse. In the other, you're talking about defendants who are alleged to have infringed patents, who are equally concerned to protect their trade secrets for similar reasons.
My Lord is absolutely right that that's what we say this court should take from the Trade Secrets Directive, that whether it was enacted specifically for enforcement proceedings of trade secrets or otherwise, the policy that's been accepted by the legislature is absolutely clear. That trade secrets must be preserved in the litigation process, and it isn't contrary to public policy to only make a non-confidential redacted version of the judgment, because the way in which sufficiently open justice, judging the judge, allowing
I understand all this, but where this all goes back to is where we started, which is Scotland Scott.
Yes.
Because where does open justice come from? It comes from Scotland Scott. What's always been a recognised exception to open justice on to protection of trade secrets.
Your Lordship is right. And I say, look, the judge could have approached this either way. He could either have dealt with Lily-Icos, reading the whole of Lily-Icos and understanding the importance of justice over open justice, or he could have gone down the trade secrets route. But either way, the test that he ended up applying, that one that we see at first in paragraph 18 and later in paragraph 36, just misses the point. It's just wrong in principle. It puts open justice on a pedestal and puts a huge burden on the trade secrets holder to justify the non-publication. There's no burden on the trade secrets holder here at all, other than to show he has a trade secret. And my Lord Justice Arnold has already made the point, in a very large number of cases, there is a significant overlap between a trade secret and material which is confidential. My Lord has written on the difference in the language and the penumbra that might exist, but in the vast majority of cases, anything...
Well, we don't need to worry about that.
Your Lordship.
Anyway,
we also...
Silverleaf needs to have some time to respond.
I'm sorry. Yes, I will do. The floor and ceiling approach of the Trade Secrets Directive, we say it would be odd, at the very least, if a dispute which was not actually about enforcement of a trade secret, but say ownership of a trade secret, wasn't afforded equivalent protection. My law referred to patent cases such as this, but I was going to take another example. A company that's developed a trade secret has gone into liquidation. As is often the case in investment agreements in those companies, they say, I'm investing money for this research project. The intellectual property belongs to the company I'm investing in. But should the company go into liquidation, the proceeds of that research intellectual property comes back to me, the investor. That sort of case comes before the court. There is no question of misuse of confidential information, no misuse of trade secrets. The liquidator says, I own this asset and I can sell it to whoever I like. And the investor says, I own that asset because it came from the research project. In order to resolve that, one has to look at what the research project was, what everyone was doing, what the alleged trade secret is said to be, and how it came to be about. It would be inconsistent, putting it at its lowest, if that type of proceeding didn't give the same respect to the trade secret as provided for by the Trade Secrets Directive. And we then say, by analogy, the same happens to a defendant in a patent case. And I conclude by coming back to Scott and Scott, which my Lord Justice Arnold has already done for me. Confidentiality doesn't have to yield to open justice. Rather, justice requires that property is not destroyed in the litigation process. Such a fully open justice has to yield to confidentiality. That's precisely the regime which we say should apply in any case, and in particular the present case, where the court is dealing with material recognised as confidential. And the judge misdirected himself by thinking that the readability of his judgment was paramount. My Lords, that brings me to the end of my note, unless I can be of any further assistance.
No, that's been very clear. Thank you very much, Mr. Nicholson. So, just on timing, Mr. Silverleaf, we're going to hear from you now, response to their appeal, and then you responding to their response to yours, and then finally Mr. Nicholson will
I'll be as quick
reply
as I
to you.
can.
Well, this is important stuff, so take the time you
So
need.
I'll deal first with my own appeal and then my response, because I will be able to wrap up in that some of the points I want to make on my own appeal. I start with the proposition that there's something special about infringement by equivalence. The reality is that the judge's judgment on normal infringement, in this case, as in many others, is just as obscure as his judgment on infringement by equivalence. The point became below, the point was focused on the equivalence argument, not least in substantial part because there was a major pleading issue in relation to normal infringement, which I really don't want to go into, but it meant that the judgment on normal infringement was a slightly odd form. But if you look at paragraph 40 of the redacted judgment, which is in tab 9 is the interim public version. It amounts no more than to an assertion. This is, sorry, tab 9, page 69 of the core bundle. The judgment on infringement by on normal basis is just an assertion that the threshold created is not dependent on a single representative of the art. The reader has no idea what the signal is or what is being done, just the same as in relation to infringement by equivalence. There's no, infringement by equivalence is not a special case.
Yeah, and as I understand it, the point you were just making is it's misleading to focus on the small degree of redaction in paragraph 40 because it all follows
Yeah.
on what the judge has set out in 39, which was your pleaded case,
Yeah.
almost all of which is redacted.
Yes. You have just as little idea of what the reason for the decision that there is no such signal in relation to normal infringement as you do on infringement by equivalence. So the answer is it's just as applicable in this case to both aspects of infringement. And I respectfully submit there's every possibility, in fact, seems in my submission to be almost inescapable. But the difficulty is going to be the same on normal infringement and infringement by equivalence in almost every case. There was a debate about whether the level of redaction should depend on the result. We say it cannot possibly depend on the result. My learned friend's answer to that is if he's found to infringe, the value of the secret then becomes minimal. But the basis for protection is exactly the same. So it makes no sense to say that a failed defendant should not be protected. Secret may become valuable once the patent expires. Apply the same argument to a failed claimant in a breach of confidence action, where it is held that the breach of confidence action fails because it has not been established that the defendant has used the secret. Should the secret then be revealed, destroying its substance? Of course not. The argument that the protection depends on the outcome must be wrong. And then there was a substantial debate about when and how you decide this. On my learned friend's approach, you cannot decide the outcome of the confidentiality provisions until all appeals have been exhausted. So you can't even deal with this on a substantive appeal to the Court of Appeal. You have to wait the outcome of any application to the Supreme Court. Justice delayed is justice denied. It is not appropriate for decisions of this nature to turn on the outcome at each stage of each level of appeal. There must be a mechanism for determining whether or not material should be included in a judgment, irrespective of the outcome and irrespective of the level at which the judgment is delivered. Now, the core of my learned friend's argument is that the judge failed to apply the Icos properly. In my respectful submission, a proper reading of the judgment shows that he did precisely the opposite. He carefully read Icos. He took into account all the Icos factors.
Well, before you get on to that,
Yep.
could I ask for your response to the more radical submission that emerged in oral argument, which was to say, Mr. Nicholson didn't quite phrase it like this, but in essence, Icos is wrong. Certainly, if you try and apply it to the kind of case with which we are concerned, because the proper approach stemming from Scott and Scott, and confirmed if confirmation is needed by the Trade Secrets Directive, is that there is no balancing exercise. Trade secrets, once found to exist, trump open justice.
With the greatest respect to my learned friend, that cannot be right. There must be a balance. The balance will be different depending on the facts of each individual case. Now, if you look at an action to enforce trade secrets, then the likelihood is that disclosing the trade secret as a result of the litigation will deprive the trade secret of its value and substance. In those circumstances, and that is the circumstance contemplated in Scott and Scott. In those circumstances, it is likely, although I would point out not necessarily certain, that the balance will come down in favour of protecting the trade secret, even after judgment has been delivered in perpetuity. Where, however, the information is of relatively little importance and concerns an aspect of the litigation, it's not that which has been enforced by the litigation, the balance may very well be entirely different. It will all depend on the circumstances. Icos must be right in principle. There will be cases in which the information has to be preserved in perpetuity, and they are most likely to arise in relation to actions to enforce trade secrets, which is why the directive and the regulations are formulated in the way they are, because they recognise that they're right at one end of the balance. And in my respectful submission, it is no accident that those regulations and the directive apply only in terms to actions to enforce the wrongful use of trade secrets, because that is where the problem is most acute. I mean, the reality is, if my learned friend were right, that there was a real problem, this is on a slightly different point, these floodgates of fearful defendants, we would have had a major problem long before now. Scott and Scott was decided in 1913 and laid down the principle of open justice, subject to exceptions. Lily Icos is itself over 20 years old. We have not had a flood of these cases. We have not had a flood of these cases because actually the system, as it is currently constructed, is well balanced and works. It is my learned friend's clients who don't like the outcome of the balance in this particular case, and primarily, with the greatest respect to them, don't like the outcome because they have not put in sufficient evidence to justify the very powerful assertions they make about the value of this information. I would point out that the hearing of the form of order following judgment in July last year was originally scheduled for September. It didn't take place then because the judge decided there wasn't enough time. It took place in December. At no point during this period did my learned friend's clients put in any evidence relating to the 3122 order and preservation of confidentiality. We didn't have time to deal with it in December, so it was put off till February. They didn't serve their evidence until the 7th of February. We served our evidence in response on the 14th of February. The hearing was on the 22nd. And the suggestion that we should be criticised for using Professor Plummer is one that I find close to offensive. We had to use Professor Plummer because pending the resolution of this issue, and remember it's my learned friend's client's application.
He was the only witness with access to the information.
Precisely. We were told only witnesses within the confidentiality club. Who else was I going to ask? And now I'm told I should have brought in an independent expert who hadn't seen the information. Well, it wouldn't have been possible for that person to do so because without putting him into the confidentiality club, he couldn't see anything. I'm very sorry, but I find that submission almost extraordinary. Now, so I say Lily Icos does represent the law. And can I come back to the criticism that my learned friend launched on the judge in relation to his application of it? If you take the judge's judgment, which I naturally find, it is in tab 11, I think, isn't it? And go to where he quotes the at paragraph 14, page 77.
He sets it out in full.
He sets it out in full. Having set it out in full, he then takes the care to go through each and every aspect of the principles there laid down. He starts with the starting principle in 15, which is 1. He then talks about 2 related balances. Point 6, which my learned friend says he didn't take into account, the balance between keeping the public properly informed and ensuring parties not free proper disclosure. Points 2 and 4 identify a related balance. Party seeking to enforce the confidentiality must establish specific reasons, balance against the relevance of the information. And then the only paragraph my learned friend directed the tribunal to, paragraph 18. Quoting this out of context and then asserting that it amounts to a misdirection by the judge of himself in relation to the law is an inappropriate submission. Read in full what the judge did. At 19, he said points 3 and 5, paragraph 25, must of course also be borne in mind. In my respectful submission, it could not be clearer that the learned judge below had in mind all the relevant factors understood their purpose and took them into account. Quoting paragraph 18 of his judgment, without the context which surrounds it, gives an entirely false impression of what he did.
Well, and perhaps slightly more importantly, because that's the first judgment on confidentiality.
Yes.
But then when he comes to the second judgment on the balance, he says at 32 and 33 that he's explained his understanding of the principles, and counsel agreed, and then he reiterates the two related balances that he identified in the previous part of the judgment.
Well, I'd understood Mr. Nicholson's submissions to be, insofar as they're critical of the judge, to be focused on this second part of the judgment. I think, I'm not even sure Mr. Nicholson in terms said that the judge directed himself correctly in the first judgment. It's when he came to apply it, it was oversimplistic approach to the exercise.
But the criticism is made on the basis of paragraph 18 that he put transparency above justice. In my respectful submission, that criticism is entirely unfounded. He had absolutely clearly at the front of his mind the need to strike the relevant balance. And in my respectful submission, struck it entirely reasonably.
And he dealt with Manitou being a volunteer and the consequences in 35.
Yes. There is nothing that he should have taken into account that he omitted to consider, and it cannot possibly be suggested that he took into account anything he shouldn't have done. The suggestion that his multifactorial assessment of the balance was in some respect in error, either in fact or in law, is one which, when one reads the judgment in full, can be seen to be wholly without substance.
Well, what do you say to the argument that, and I think it's really, I mean, maybe I assume you're going to come to this, but it's ground 3, really, I think, about playing down the damage to Manitou. I mean, don't let me take you out of it.
No, I think I have a shrewd suspicion. This is paragraph 67 of his skeleton. I'll just come to that. Hold on. That's the next bit of my note. Yes, my note took you through ground 3, paragraph 67b. It's tab 15, core bundle 178 to 179. The judge did not put transparency above justice. He concluded on the evidence that the damage to Manitou, by revealing the nature of criteria, was minor, possibly even trivial, and that open justice therefore outweighed that damage. He applied the Lilly-Icos test precisely and completely. Now, looking at the points made on ground 3, Professor Plummer's was the only evidence in relation to the damage. To say that the judge was wrongly swayed by Professor Plummer's evidence that such a benefit was dwarfed by the huge amount of work that would be involved in developing a commercial product is not, frankly, it's not open to Manitou to say that. They had every opportunity to put in evidence to explain why that was not the case. They did not do so. Their evidence is pure assertion, and I should show you that. But just before I do that, I will go through the criticisms that are made in the paragraph. The appreciable shortcut at the top of page 117 at 9. There's no basis for the argument that a competitor would reading the information without having to conduct a detailed investigation would achieve an appreciable shortcut. Plummer says otherwise. That evidence is unchallenged. That also deals with Manitou's item 3, Manitou's self-evident assertion. Note that it is admitted to be an assertion, that revealing the concept would provide competitors with a strong signpost, and so on. Professor Plummer made clear precisely why he said that it's a matter of practical reality, knowing the nature of criterion X would give competitors no useful lead at all. If it was to be my learned friend's case that that evidence was wrong, it was his obligation to put in some evidence to counter it. He did not do so. And I might suggest that you could reasonably infer that he did not do so, because it would be very difficult to do so, given the complexity of the system. Criterion X is not unknown, as suggested in 2. It's just not used by anyone else. There may be a very good reason for that. It is complex to engineer, and contrast that with the, if I may put it like this, simplicity of the direct application of the claimed invention, where I read you out what it does. It's very easy to see, and you can apply that directly to the control system of the machine. Therefore, what is said in 4 is wrong. It is not the same level of generality or the same level of difficulty to implement. The invention, as described precisely in the patent, can be implemented very straightforwardly. Manitou's attempt to engineer around it is very complicated and difficult and takes a great deal of work. The two are not equivalent. And we say, as your lordships and your ladyship will appreciate, that actually properly understood, what they have done is taken our concept and used it with bells and whistles. My learned friend, well, actually, no, before I get on to that, can I just take you to Mr. Bevan's evidence? Because there are a number of things which need to be drawn out of that evidence. That's in the supplementary bundle at tab 6. The substance of the evidence on confidentiality starts at paragraph 11, which is at page 152. The paragraphs 5 to 10 are, and I mean no disrespect, it's simply polemic. These parties are, as my learned friend has said, vigorous, not to say vicious competitors. They have been competing with each other for decades. They sue each other everywhere. It is how they do business. That's their relationship. That's what 5 to 10 tell you. I don't want to read out or ask you to plough through. Paragraph 11 simply sets out what they say is confidential. Paragraph 12 asserts that something is confidential, but doesn't give any reasons why the confidentiality is significant or important. Paragraph 13 merely says no one else uses this mechanism. Paragraph 14 addresses the point that you can deduce the nature of criterion X from what is used in their machine. It concludes an allegation about the angle sensor, which is found on a Manitou machine. That's the pleading point. The pleading was a mess. I freely accept that. It should have been a lot better. Then paragraph 15, which I've shown you earlier, just deals with the number of systems, and I pointed out that what that shows is that even knowing precisely what they are, the engineer who designed this still had to do lots of experimentation. So imagine how much more you have to do if you don't know how precisely how they are engineered. Paragraph 16 acknowledges that we pointed out they published one of the systems in a patent, to which their answer is, oh, well, it was filed earlier than this machine was designed. Well, that's what one would expect, otherwise you'd have prior published yourself and your patent would be invalid. I don't understand that answer. They have published that technique. It is not a secret. This is Mustad and Dosen in terms.
So just to make sense, that the middle of paragraph 16 refers to the patent.
Yeah.
And that refers just to one of the
Yes, it refers.
subsystems.
Yeah, but you can, by looking at their patents, you can find that technique fully described. So it doesn't take a great leap of imagination when looking at a machine to realise actually the way this machine is working is what's described in that patent.
Or that the manufacturer might have used that because it is one of their patents.
Exactly. The paragraph 17 points to Professor Plummer's trial evidence, which was to the effect that another of the systems would be primarily effective on startup, but might have some effect later on. Its effect is immediately apparent because the machine does not respond in the way that you would anticipate from the control impulse. And the way in which it does not respond is also apparent. So Professor Plummer said, this is what it will do. There is no evidence here that you can't deduce what Professor Plummer was saying. Professor Plummer was saying, this is what you would expect it to do. So precisely contrary to my learned friend's submission, there is actually no positive evidence that these things are confidential. And then we get on to the detailed descriptions, as to which there's no dispute in paragraph 18. And then the acronyms. Well, the acronyms simply tell you what the nature of the control parameters are. That's it. That's the evidence. That is all they put in. Now, in my respectful submission, if you put in evidence of that quality, you cannot come to court and complain when evidence is put in answer which says, actually, these things are apparent from inspection of the machine and reading the judgment. And you can't complain when the court says, well, actually, I prefer the evidence of the mechanical engineer who tells me what I can see. It's as simple as that. They had months to put in better evidence. They had an opportunity to reply to Professor Plummer. What they're now trying to do is, through my learned friend's skillful and elegant advocacy, make good the complete deficiency of their case on the facts. It's not good enough. Picking up my learned friend's further points, my learned friend said that the approach we are proposing would drive a coach and horses through the confidentiality ring protection. I respectfully say that's simply wrong. I point out that we've had this practice, this approach has been put into practice throughout my career, which is no longer short. Lily Icos is more than 20 years old. There has been no problem with this. In this particular case, you only have to compare the extent of the information and detail in the PPD with the very limited information that is proposed to be made public in the judgment areas, to see that 3122 and sitting in private have precisely and completely achieved their purpose. The system works perfectly well. I've dealt with fearful defendants. I've dealt with trade secret, the impact of the Trade Secrets Directive and regulation. And I've made the point that the balance will always depend on the facts. So, just very briefly to reply on my own application.
Yes.
As I've said, these parties are at each other's throats. We can both throw prejudice at each other. The 382 is not in issue in Italy. My learned friend's clients have produced experiments in Paris, which, by the time I'd cross-examined Mr. Cadu, were quite clearly misleading. So what? We're all at it. My learned friend's submissions on my appeal did not, in my respectful submission, properly address the requirement for misuse for an action for breach of confidence to arise. He tries to distinguish protection cases from misuse cases, but the problem with that attempt to distinguish them is that you cannot have a protection case unless the information is in principle protectable. Whether or not that is the case is determined by the law derived from the misuse cases, because the information is only protectable in circumstances where it's been misused. Unless it would be a misuse to use the information, there is nothing to protect.
Yes, there doesn't have to be a misuse, but if there were,
Yes.
it would be protected.
Yes. But unless that circumstance, unless you can identify something that would be a misuse, there is nothing to protect. He seeks to undermine Professor Plummer's evidence on the basis of hindsight. This is a wholly illegitimate attack. It was not made below. And it is not open to my learned friend to say that Professor Plummer is wrong when he has chosen not to put in evidence to challenge it. He could and should have put in evidence to explain why Professor Plummer's analysis is flawed. And frankly, I would ask you just to reread paragraphs 3.4 to 3.6 of Professor Plummer. Look at them and say to yourselves, what's wrong with that? It's entirely logical. He explains precisely what you see. And he is a very good teacher, if I may say so. He explains precisely why a mechanical engineer looking at the machine in the form in which it is found on the open market would be bound to come to the conclusion that the parameter being used is criterion X, because that's all there is. You can look at all the things that have been measured, and the only thing available to achieve the outcome which is accepted is criterion X. My learned friend made a number of points about endorsement being better than reverse engineering. I regret I don't understand his point.
That was me, wasn't it? He accepted what I.
I'm sorry.
So it may not be right.
In that case, I'm being unfair, and I apologise.
No, don't.
I shouldn't be criticising you either.
Put a softer target. But my point was that it's one thing to reverse engineer and come to a pretty settled view this must be what they're doing. It's of a slightly different, if not in some cases a wholly different level of confirmation to have the judge saying this is what they said they were doing and here's the detail of it.
Well, of course, you don't get the detail. All you get is
I forget that.
all you get is the headline, if I may put it like that. And in my respectful submission, the value of the information is no different once one has reached a firm conclusion as to what is being done. And Professor Plummer's evidence is utterly clear. There is only one candidate. You don't need confirmation. Again, it will all depend on the circumstances. In some cases, the confirmation may make the deduction that you've arrived at more certain. I mean, I probably shouldn't give this example, but the origin of COVID-19. There's all sorts of theories and crackpot ideas. Anything that gives you real purchase on where the COVID-19 virus may have come from would be very, very helpful and give one hugely increased confidence in understanding the evolution of the disease. We are not talking about that kind of case. We're talking about a case where a mechanical engineer can look at something and say, you've got this, this, and this. That's how it works. So, in my respectful submission, it does not make a difference that there is confirmation. There are, in my respectful submission, overwhelming difficulties with my learned friend's approach apart from this, because although he says he would accept a publication proviso, the difficulty with that is that, as I have explained in my submissions, the relative confidentiality principle applies when the information can be derived from other sources, and therefore protection is limited in time and in value. That is not what we're talking about here. What we're talking about is whether or not the reasoning of the court should be opened up to the public. And that is a completely different concept. And accordingly, you cannot apply those limited protection factors to the question as a matter of principle. I could say one or two more things on the trade secrets directive. Yes, his submissions on the shortcut provided by the information are all dependent on there being a legal basis for preventing the shortcut. And that's all provided by the misuse cases. On heads 2 and 4, this is an application by Manitou to protect their information. It is for them to justify keeping this information confidential. I've shown you Mr. Bevan's evidence, the limited nature and quality of it. The problem for Manitou is they simply haven't provided the court with the evidence that justifies the relief they seek. And they've had ample time to do so, and accordingly it should not be open to them to say, well, we could have done better with hindsight.
Yes.
Lord, I've been very quick, but unless you have any questions, I don't think there's anything else I've missed.
No, you haven't expressly dealt with the trade secret
Right, well,
matters. I don't know if there's nothing you wish to deal with, then don't.
well, let me say this. In order to be a trade secret, under Article 2, so if we go to the authorities, the authorities tab 11, Article 2 definitions. Trade secret is a secret in the sense that it is not a body or imprecise configuration of certain components, generally known and already accessible to persons within the B has commercial value because it is secret. So both of those tests have to be met. Criterion X meets neither test in my submission. It can be observed either by running the machine and seeing that it is not using an angle sensor, or by reading the redacted judgment. And on the evidence, again, this is Professor Plummer's evidence, it's not of commercial value in and of itself. So it's not a trade secret in any event under the regulation. The submissions that English law would be below the floor of protection provided by the directive if it didn't protect Criterion X, ignores both those factors, and therefore their case fails on the facts. In my respectful submission, the approach under 3122 is entirely consistent with the requirements of the Trade Secrets Directive. The regulations and the directive apply to actions to enforce trade secrets, and I've already explained that in those circumstances the balance will be different. We have perfectly good mechanisms for protecting trade secrets. We all know that other jurisdictions have more problems with this. We have a very good system for dealing with confidential information and trade secrets in the form of confidential information in the form of trade secrets. The balance is going to change depending on the importance of the secret, its value to the secret holder, its centrality to the judgment. In a case such as this, where the secret is on the evidence of, assuming it's a secret of very little value, because it doesn't actually take you very far, and it is impossible to understand the judge's reasoning without knowing the fact, in my respectful submission, it is very clear the balance, assuming it is a secret, comes down in favour of disclosing it.
Thank you. Nothing else? Thank you very much. This is, just to be clear, this is your reply to Mr. Silverley's response to your appeal.
I'm grateful. I'll tell you this very shortly. First point I just wanted to stress my ultimate lady on is paragraph 18 of the judgment, how it sits with respect to that. The point that I made about court up 11. The point that I make is not that the judge didn't set out Lily-Icos in full, not that he didn't make a discussion of different values, but that the test that he comes to at paragraph 18 was reached only after the parties had argued confidentiality. And if you roll forward to the top of paragraph 31, there's a further judgment. And between those two, all the issue on balance was argued out before the judge. So we set out the relevant points, gave a test at paragraph 18, decided what was going to happen, and then he records the submissions and goes straight back to the test he's already decided.
Can I ask you this question? Look at paragraph 32.
Yes, ma'am.
He says there, this morning I explained my understanding of the principles that derive from the judgment of the Court of Appeal in the Icos case. That's the judgment that's transcribed down to paragraph 30. And then he says, counsel on both sides agreed with that understanding. Is that a correct statement or not?
Both of us stood up after, as we started into the in-between submissions and tried to make submissions on Lily-Icos. And the judge said, I thought you said it was all done and dusted earlier. So there was certainly some confusion between my learned friend, myself, and the judge as to whether or not we'd argued out all the relevant balancing factors on the publication issue, because we hadn't. And one can see that as one goes to the transcript. As we came back after it, we both tried to argue further as to what the balancing factors, and the judge allowed.
Well, when you came back to argue, were you arguing about the facts of this case or the law?
So parties divided the submissions into two completely separate sections. Firstly, much as we've done on this appeal, firstly, is the information confidential? Without regard to why we care whether it's confidential.
That's the first
and then
part.
secondly, the publication on the Lily-Icos. Neither of us, I think I'm right in saying, neither of us referred to Lily-Icos at all before the judge gave the first part of the judgment. So he gave the first part of the judgment, setting out all the bits from Lily-Icos. And then we came back for the argument about what Lily-Icos meant, what the balance was, and how we had to deal with it. And the judge locked himself in on, I already said, did you have any problem with what I said on Lily-Icos? Which both of us said, well, we wanted to say a few extra things about it, given that you've already set it all out.
All right, well, I'm grateful for that clarification, but what then do you say about paragraph 33? Because in there he, in essence, repeats his distillation of the two balances from Lily-Icos. So to be clear, is it your submission that paragraph 33 is a wrong statement of the law?
My lord, what I say of 33 is it's oversimplistic. It's following the same line. I've only got two things to worry about here: open justice and harm to the party. And that doesn't reflect Scott and Scott. It doesn't reflect those other considerations in 25.5, 25.6. Right back at the outset, before the judge had been addressed on it at all, he decided that the case needed to be decided on the basis of, is this important in the judgment, and then the burden of evidence on Manitou. And recorded are the submissions that are made, recorded are the various paragraphs of Lily Icos. Every time he comes back to it, he comes back to the same thing. 18 before he's heard argument, is it important and is there real harm to Manitou? 33 the same, repeating it again, and then it really comes to a head at 36, turning to the specific of the case. That's the test. Because as he records, he received submissions on all these other matters, but none of them feature. The next question, which I respond on, which is of some importance, is my Lord Justice Arnold asked my learned friend what he says about the misdirection as to Professor Plummer's evidence. And that led to my learned friend going on about Professor Plummer's evidence for some time. All of it went to confidentiality, and he never addressed the real point that was being made, which is not about the size of the work of the overall project, but rather about the benefit of the material that was being disclosed to the opposing party. It's very easy to see in the context of a huge, great engineering project that a gobbet of information is relatively small. And Professor Plummer said that. We don't disagree. But that's looking at the wrong thing. You've got to be looking at what you are being given, which is Manitou's confidential information, the criterion X, the start of the path that sends you off in the direction. And that, we do say, is akin to the sort of direction one gets in a pattern, saying the secret to making this machine is you use these parameters, or whatever it might be. I don't want to overspeak and reveal confidential. This is the way of the technique to go about it. Now go build it. Now, of course, you go off, you do experiments, you have failures, you have successes, but in the usual patent world, we say that the patent is sufficient because the information is giving you enough direction to go off and do ordinary engineering effort and put it into effect. And what's happening with Professor Plummer's evidence and what the judge was led into doing was seeing all of the big project and taking his eye off of that bit at the beginning that sends you off down the path. My learned friend says the system works very well. It's worked very well for decades. It's very, very well in this case. We've had a 3122 order. We sat in part in private. That's all fine. It protects the information throughout the throughout the core process. But it's pointless us wasting our time doing that if by the end of the process the information is made available to the public. The only reason that we do pro tem steps through the course of the litigation is, as my Lord Justice McFarlane and I were discussing at one point, it saves the burden, it saves the effort on focusing on stuff that doesn't matter. But the final important step, which my learned friend wishes to ignore, is the stuff that does end up in the judgment, the stuff that is important at the end, still needs to be protected. There's no point in me having had protection for the last 3 years if it's then thrown open at the final throw. Now, my learned friend was asked whether the position is consistent with Lily Icos. And my learned friend says Lily Icos is consistent with the Trade Secrets Directive. But the Trade Secrets Directive is at one end of the balance, where the information should be preserved often in perpetuity. And we say that is one way of looking at it. If you look at Lily Icos properly in the round, taking into account what this court said about Scott and Scott in Lily Icos, then you end up with something akin to the trade secrets. Lily Icos only goes wrong when you look at paragraph 25, ignore what the court recognised from Scott and Scott, and treat this as a balance case and only look at the two limbs of the balance, which the judge was considered to be important. Then finally, my learned friend said, on not a trade secret, he took my lords and my lady to the directive and to Article 2. Tab 11 of the authorities bundle. And it is page 305. He said it's not a secret if it's readily accessible. That takes us round the loop again as to what readily accessible is. We say the reverse engineering that Professor Plummer has in mind is far more than readily accessible. He then says it doesn't have commercial value because it's a secret. And again, he looks at the totality of Professor Plummer's overall project to a commercial result. He says because it's only a tiny bit in that overall project, it can't have any commercial value. Whereas we say you're looking at the wrong thing. You've got to be looking at the inventive concept, at the nugget. It's at the same level of detail as my learned friend's patent. It clearly is of commercial value. And then my learned friend made no point as to being kept confidential, taking reasonable steps to control the information. But the mere fact that the court has found that it is confidential demonstrates that steps have been taken to keep it protected, otherwise it wouldn't be available. So we say that if one does apply this on a trade secrets basis, it's not readily accessible, it's been kept under control, and the evidence that you have, limited though it is that it's considered to be of commercial value. Indeed, if you step back and say, what is it that allows Manitou to compete directly with JCB without infringing its patent? It's its use of its system built on criterion X. And that's why it's valuable, that's why it should be protected. And it shouldn't be made available for the others in the market or for my learned friend to take and use in other litigation where they don't have disclosure issues. My lords and my ladies, subject for any questions.
Thank you very much. No. Well, it won't surprise you that we're very grateful to both leading counsel, but also everybody in the ranks going back in the room. This has been so well prepared and so clearly presented. Doesn't make the answer any more straightforward, but at least we understand the question, I think. We'll reserve our judgments. We'll endeavour to prepare them as quickly as possible, but at this stage of the year, that's never a luxury we have in terms of very swift time. We'll circulate them on the usual basis to encourage you to spot the typographical errors which are bound to be there, but not to engage any further in submissions. We don't anticipate we'll need to have any attendance when we hand down, but if there are any ancillary matters, such as the ones we discussed, obviously, we'll endeavour to deal with those on paper.
Very much. I would hope that, in the light of what your lordships and your ladyship decide, we would be able to work out the consequential impact. I very much hope we wouldn't need to trouble you.
No. If you do, it'll be a pleasure to see you all again. Thank you.
Great.
Court rise if able.
Famous ascertained.